Hey folks, welcome back to the channel. In today's proceedings, the courtroom prepares to sentence a former teacher's aide who admitted to a sexual relationship with a student. But you wouldn't know it from the way her legal team spins it. They shift the focus to blurred memories, questionable timelines, and her community standing. Missing from the narrative, however, is the part where she used her position at a school to cross a line she had no business even walking near. Let's watch this carefully arranged performance that stops just short of admitting what everyone already knows.
Rose Booms, 247190 FH, time and date originally set for status conference, but it is time and date for sentencing. Booms is present, represented by Nicole B. Becker. People are represented by prosecuting attorney Timothy J. Rakowski. Before we proceed to sentencing in this matter, as stated, this was scheduled for a status conference. Back at the original sentencing date, which I believe is March 24th, the court stated that based upon the plea agreement, that the court would not be able to sentence or follow the recommendation of following sentencing guidelines. What the court did do originally when these pleas were entered, the court had taken the pleas and advised counsel that the court would stay within guidelines. After review of the pre-sentence report in this matter, the court could not do that and allowed Ms. Booms the opportunity, if she wished, to withdraw her plea. The court, when it takes pleas involving any type of matter, frankly, the court will not look out for media reports or find out what's going on in the background. For instance, some cases receive an intense amount of media attention. Apparently, this one's not the exception either. But when the court accepts a plea, the court doesn't know any factual information regarding what may have happened. All the court knows is that the defendant is charged with certain crimes or crime. And once the court either gets a factual basis at the time of a plea being entered, or obviously after review of a pre-sentence report, that's what the court knows. For instance, and this has been a few years ago, but I recall a defendant that was charged with, it wasn't fleeing and eluding, but leaving the scene of a personal injury accident. And come to find out, until the court read the pre-sentence report, had no idea that involved the medical care facility in Bad Axe a couple of years ago. Again, the court had no idea about that. And the reason for the court not having any idea behind any alleged facts of any particular cases, the court does not want to prejudge anything. The court will receive the information that's contained in the file from either the parties, testimony, trial. I'm no different than a juror, essentially. And that's what the court does. And again, the reason for that is because I don't want to have any preconceived notions before we proceed any further. It's just in fairness. As a matter of fact, the court takes the liberty when it comes to arraignments or even trial dates. If there's habitual offender information, I don't even read that as well. And the reason for that, again, I don't want to have anything in the back of my mind saying, well, geez, there must be something going on. I want to be like a juror. That is, someone who doesn't know what's going on until the trial is completed. So that's why the court does what it does. And sometimes it can be reported in social media posts. It can be posted in comments regarding newspaper articles that, you know, the court does this and the court does that. Well, the court, when it comes to any particular case, will not review any prior information, will not do anything unless it's entered in the courtroom, period. So the court accepted the plea back on on February 3rd. The court stated that it was the intent of the court to stay within the guidelines, and if the court could not stay within the guidelines, this would be allowed to withdraw her plea. I've been advised by Ms. Becker in a phone conference with Mr. Rakowski, because there's no ex parte communication either. There never was and there never will be. I was advised by Ms. Becker that Ms. Booms wishes to continue with the acceptance of her plea and to proceed to sentencing with the understanding that the court cannot follow or will not sentence or at least be within the guidelines. Ms. Becker, is that a fair assessment of our conversation?
Regarding our conversation, that is true.
Okay. Mr. Rakowski?
It is true.
Okay. And so the court has accepted the plea again on February 3rd. That was the date of plea that was entered in this matter. A pre-sentence report has been prepared by Mr. Nathan Licht. That report is dated February 21, 2025. There are a ton of additional documentation provided in the form of sentencing memorandums, letters. The court's reviewed all of that. The court has reviewed the pre-sentence report as well. And the court is aware that there's an objection to the scoring of the guidelines as well. Before we go any further, though, Ms. Becker, have you and your client had the opportunity to review the pre-sentence report?
Judge, may I just address one more thing?
Sure, go ahead, please.
Thank you. I just want to make sure that the record's complete. What happened back on March 24th, 2025 is when you took the record, excuse me, when you took the bench and you were making your record, you indicated that the court will not accept the plea agreement and will leave it at that. So I think because of those statements, there was a lot of confusion on our behalf. I would say the prosecutor may admit on his behalf as well, because the plea had already been taken. So I just want to make it clear that you were not saying you're going to not accept the plea. As you indicated earlier, you said the plea was taken on 2/3/25 and the plea agreement stands. However, it was something regarding the guidelines that you couldn't stick with. Is that correct?
That is absolutely correct.
Got it. Okay.
That is absolutely correct. And the court did misspeak regarding that because I guess I just treat it as a full package deal where we got the plea entered, sentence within guidelines, and that's why the court said what it said, and it was an error. The plea was accepted. There's no question about that. The court is bound by that, and the court will stick by it.
Thank you.
Mr. Rakowski.
Well, because I can cover this now versus in my elocution at sentencing, but I wish to point out, because there's a lot of people that follow this, whether it's this case or other cases, and they don't understand fully as to how the system works. And to begin with, Ms. Becker and myself are the ones that negotiate out a plea agreement. My office is the one that extends it. The court has no involvement whatsoever. The court deals with sentencing, as the court has pointed out. So, you know, anything as it relates to the plea offer, that's with me. I take into account the police report investigation. I consult with victims' families on things, and then based on all the facts and circumstances, we make a plea offer. And that's what we did in this case. So I just wanted to be clear, so if anybody has any misconceptions, and well, the court did this or the court's involved with that, the court really isn't. The court's involved now at time of sentencing, but as it relates to the plea offer, that's extended by myself in the office. And we have discussions between Ms. Becker and myself, and that's where we're at. So you know, for people that may not understand fully, that's how the system works. We deal with charging decisions, we deal with plea offers. That is what we do. The court deals with the sentencing portion. Ms. Becker and myself are going to argue here shortly. We get to argue our respective positions on the case, and then the court ultimately will make that decision. But as it relates to the plea offer, that is with the prosecutor's office, and that's what we've extended.
Any comment, Ms. Becker?
Your Honor, my comments will be when I do the allocution, I address this issue.
Okay.
Thank you.
And I appreciate that, Mr. Rakowski, because there is a separation of power between the executive branch and the judicial branch, and that might be a little muddled now as what we see going on in our government. But when it comes to this court and that prosecuting attorney's office, our prosecuting attorney's office, the court doesn't know the facts. The prosecutor may be aware of the facts through the investigation, and he has the authority under the under his power as a prosecuting attorney to offer plea agreements if he wishes to. And if he does, he does. It's not the question of the court to say, you know what, that's a bad deal or that's a great deal. I'm not saying that at all. But you have the factual information where the court doesn't. And so I really do appreciate that comment, Mr. Rakowski. At the end of the day, yes, the court is involved with the sentencing, and that's as far as it goes. But I'm glad we were able to clear that up. Now, with all that in mind, You've reviewed the pre-sentence report with your client.
We have, Your Honor.
Any additions, deletions, corrections, or objections to the report other than guidelines?
Correct, Your Honor. The guidelines are an issue. However, I would bring up one issue that I believe should be addressed. And it is with regard, it's on page 5, although I know this is not consistent in its numbering. The top part says Michigan Department of Corrections pre-sentence investigation would be the last paragraph on that page. Sort of towards the end, Your Honor. Maybe a few pages, 8 pages before the actual guidelines.
And which section?
Thank you. The last paragraph starts by saying at a later interview.
Yes.
Okay, thank you. Your Honor, if you go about 4 lines down, and there is an indication there that there was a child advocacy center interview, which there was in fact, and it indicates very concisely that the victim in this case it says that he and Kimmy first had intercourse in April of 2024. Your Honor, I have the transcript from the care house interview. And almost every time he talks about the first time, he either says, I think, yeah, I think, or he says, it happened the weekend after. The weekend after school was over, my client was already no longer working for the system. This has been a huge contention with the prosecution and the defense, obviously, when my client was in fact a teacher, when she wasn't, because the law says that if she was not a teacher or consent and sexual intercourse per the law is okay if you're 16 or older. So I just wanted to point that out, that within this pre-sentence report, it commands that was the date. And I would just indicate a further review of the transcript from the Child Advocacy Center, specifically at least 3 times when he's asked about the first time. I think it was April, I think. And even one time he says something to the effect of, it was the weekend after, and school was over the weekend after the weekend. I'm sorry, I should be more specific, of a bus incident, which is what started this whole investigation. So, Your Honor, with regards to that, I just asked that perhaps we could add the, for lack of better words, quote, I think, because I think that makes, I apologize, but truthfully, you either know or you don't know, with all due respect. In his 6 interviews, by the last interview, which is this Child Advocacy Center interview, which is typically the information that's used by the prosecutor in order to determine the charges, I think that's really important that that is added.
Mr. Rakowski, your response.
My response would be that from the investigation, I believe that is the CAC interview that's provided to the prosecutor's office. The police have that, and the police would have reviewed it when they're doing their report. All the information Ms. Becker's talking about comes from the police report. That would be my understanding.
I'm sorry if I misspoke, Judge. It's coming from the care house interview. It's the words of the victim at the care house interview. So.
And I understand that, but that is what is a synopsis that comes from. I don't believe they're looking at it, or maybe they are looking at it, but my understanding would be it come through the police investigation report, and then the evaluation and plan usually lists off things that come from the police report. But Mr. Lick better identify that.
Let's hear from the audience. It's a combination of both. I reviewed the CAC and the police reports. I'd have to look at my notes.
Why don't you take a look at your notes?
Yeah. guess it came from what I interpreted from the CAC interview, because I did not see in my notes where it came from the police report. I've got a note here from when they talked about what defense is talking about, where the victim indicated no sexual intercourse. I reviewed the supplemental after, and I cannot see where it's noted anywhere in my notes for that.
Okay. Mr. Rakowski, anything else?
No, without reviewing the CAC again, in preparation of it, I couldn't make any further comments on it.
Okay. All right, the court is going to add to that last paragraph where on line 4 it begins residence and said that he, after he, enter the word believes or thinks, use thinks, said that he thinks he and the defendant first had intercourse in April 2024. Or it was the weekend after. So we cover it. No, is that acceptable?
Yes, Your Honor, thank you very much.
All right, thank you. Anything else regarding the report other than guidelines?
No, Your Honor.
Mr. Rakowski, any objection to the report as well as guidelines?
No, Your Honor.
Go ahead with your guideline.
Thank you, Your Honor. Your Honor, I did supply some information to this court regarding our guideline, our guideline argument. I do know the prosecution also provided a response. And here's my argument with regards to OB 13, where she had received 25 points. And that specifically is for all crimes within a 5-year period, including the sentencing offense. So in order for the prosecution and or the probation to give him a 25 points, the question becomes whether or not grooming automatically means force or coercion within the context of the legislator's intent. And are there in fact other crimes that can be counted within the 5 years of the sentencing offense? The prosecution, as you know, Your Honor, initially charged criminal sexual conduct 3rd degree. The element that was used to charge that particular charge was teacher-student. Notably, force or coercion was not used. However, the prosecutor did in fact indicate to us, the defense, that on several occasions, if we did not plead, we would be going back to district court to add additional charges of CSE 3 that came out of a future relationship between Kemme and the victim. In other words, after she was no longer a teacher, that there was continuous relationships between the two, and the prosecution has told us, and has told us many times, that they were going to add charges for that. This becomes the issue when we talk about OV 13. Once she's no longer a teacher, in order to try to charge her or attempt to, or charge and then perhaps not make it past the exam, they have to add force or coercion. The support that they've given for force or coercion, because we've had this discussion, Your Honor, was grooming. Well, you groomed her, so that's force and coercion post her not being a teacher. Your Honor, I did an enormous amount of research trying to figure out if there is even a case that says that grooming means force or coercion. Couldn't find one. In fact, I found 5 cases where grooming was mentioned in the same opinion as force or coercion, but there simply is not a case that supports that grooming equals force or coercion. This would suggest that anyone who is allegedly grooming someone, i.e. a student in school, prior to turning 16, is indefinitely prohibited from having sex with that child because they are the alleged groomer. Once that, I should add, once that person is no longer a teacher at the school. The law just doesn't, regardless of how we feel about it, the law doesn't penalize that. The moment a person, as you know, Your Honor, turns 16 in Michigan, the line is drawn. Therefore, in order for the prosecutor to legitimately charge additional counts of criminal sexual conduct in the third degree, force or coercion must be present. The definition, Your Honor, of force or coercion is that can either use physical force or did something to make the victim reasonably afraid of present or future danger. Neither of those things occurred. Both legitimized by what the victim has claimed this entire time and what the defense is representing to this court. If there was no legitimate way to charge criminal sexual conduct third degree post my client being a teacher, then there's no additional charges that can be considered for purposes of OV 13. Under those circumstances, Your Honor, I would suggest that the second question that I brought before this court, which is, are there in fact other crimes that can be counted within the 5 years? The prosecutor again points to 3 or 4 CSC 4s that they claim occurred prior to my client resigning. And those should be used for the OV 13. Their support for this notion, Your Honor, comes from 2 of the 5 different statements made to the police by the victim at different times during their investigation. The prosecutor basically cherry-picked statements from 7/24/24, another statement taken on 7/25/24. There's no quantification time in their allegations. Neither have a date listed for when these incidents allegedly occurred ever been set forth. While date, I understand, is usually not an element in a CSC case, in this case, dates are very important when it comes to age in the law. The interview that is typically relied upon amongst prosecutors is the ultimate, which is the Peer House or Child Advocacy Center interview. It was done, and it was the most recent interview of all of them. It was on August 8th, 2024. Within that particular interview, Your Honor, the victim is asked over and over again about whether there were, quote, other things than making out prior to sex in what he believes could have been or thinks was in April. And he says that prior to the defendant, is what it said, to May resigning, there was grinding, there was oral and sex one time prior to her resigning. If those incidents all occurred prior to her resigning, and in fact, I have the excerpt in which he's questioned and answered about. There are no additional charges while she is in a position of authority in order for those other charges to be added as crimes within the 5 years. Under those circumstances, Your Honor, I would ask that you remove the 25 years, noting that even with removal of the 25 years, her guidelines are 0 to 17. I mean years, sorry, 25 points.
I got you.
Yes,
Okay.
thank you.
Okay. Mr. Rakowski, your response.
As we listed off in our response. So, and Ms. Becker's correct. We did say that we would bring additional counts for the activity after that she left. It would be under a new theory. How it would resolve in the courts, we would argue. We were willing to argue that. But we don't believe we have to get to that point, because when we look at the statement that we relied upon and we gave to the court as part of our response here, there is various CSC fourths. They are person offenses. So we have the one CSC fourth in which she pled to, and I believe that had to be the date of offense we used was April 29th or April 30th. So the statement talks about an incident that happened mid-April, so it's before that, of watching a movie, kissing, and then it said we kept grinding, moved off to the side, she reached down my pants, she started rubbing my penis up and down. So there's one incident right there. And then you have the previous CSC fourth that she pled to, so there's two. Went back to grinding a bit, and then she reached inside my pants again, rubbed up and down. There's CSC, another CSC third count, or excuse me, another CSC fourth count, which is a third instance. We went back to grinding again, which would be a fourth count, ended up finishing in my underwear. And then he talks about this other incident of being in the car. We started grinding like before, and once again, she reached in my pants, began rubbing up and down. There's a fifth CSC fourth count. So for those, it doesn't say that it requires a conviction. It doesn't. So under the guidelines for that, it has to be a person offense within 5 years, whether or not it results in conviction. So we've listed off that in the answer. We've attached the statement that was given by the victim in this matter, and we would ask that the objection to OB 13 be denied for that reason. And I'm not going to get into arguing what happened post resigning as a teacher, or I should say teacher's aide.
Your Honor, can I just respond to that?
Yes, I was going to light that up.
Okay, great, thank you. Your Honor, the arguments that were made just now with regarding, and as well in their response to this guideline issue, focus, as he just said, on the grinding, and then this resulted in a 4, and over here there was grinding, and that resulted in a 4. The CAC specifically says that the victim remembered the grinding the same night that they had intercourse. And we know from the argument we just made, he doesn't exactly know when that date is. Therefore, they are the dates he listed as well, Your Honor, were 4/29, 4/30. The date we pled to was 4/28. These are all items that he is indicating happened after, post her being a teacher. And if you follow what the victim himself said, not in the 6 different interviews that he gave with different scenarios, that was my point of cherry picking. It's the last interview in August, the closest to when my client was charged. And it specifically says in there, or should I say, the victim specifically says he believed that the grinding was on the same evening as the first time they had intercourse. Thank you.
You're welcome. Under OV 13 for continuing pattern of criminal behavior, MCL 777.43, 25 points would be scored if the offense was part of a pattern of felonious criminal activity involving 3 or more crimes against a person, citing MCL 777.43, parens 1, parens C. The defendant in this case is claiming that based upon review of the CAC interview, comparing notes going back in time, that it does not rise to the level of the 25 points, and potentially looking at behavior after the plea date of April 28th. In essence, prosecution's response is that these alleged incidents occurred in mid-April, and the statement was cited in paragraph 7 of people's response. But before I make a decision, Mr. Link, you did score this at 25 points, and your reason for doing so.
When I went off with the it's in my evaluation plan, the defendant engaged in sexual intercourse estimated 10 times. So I'm sure.
But regarding the prior allegations here, you did score at 25.
Yes.
Your Honor, and if I may, if you could just maybe indicate and let us know where the 10 times sex came from, because I never heard him say that.
That was a comment I don't know for certain. If it's
I remember
the
reading it too.
CSC, but it was from one of the 2.
I do recall reading that as well. I'm not sure where.
Yes, I did read it too in the pre-sentence report, but he has never in any of the interviews said that they had sex 10 times. Sorry,
All right. Well, Mr.
I
Rakowski, you
think
want
to
to?
shed some light on that, I think it was 5 different times in which there was oral sex and penis vagina sex. That's what was alleged.
That would make more sense.
Yeah, so not 10 separate occasions, but 5 separate occasions, and I don't believe that would include the CSE force, but that's different.
Okay, I think I've got it. All right, 25 points would be scored in that scenario if there are 3 or more crimes against a person. The court looks at the defendant's statement as listed in paragraph 7. Also review the pre-sentence report. The court finds that that was prior to, it was in sometime in mid-April. The quote, in the middle of April, we were watching a movie, we started kissing, and I'm not going to go into all the rest of the details of it, but when you look at the behaviors on that particular occasion, the court finds that the essential elements have been established by a preponderance of the evidence. As a result, OB 13 is properly scored, and the objection is noted but respectfully denied. Any other guideline issues?
No, Your Honor.
I'm
that
sorry,
was-
Ms. Becker.
I'm sorry.
Anything you'd like to say on behalf of your client before the court closes?
Yes, Your Honor. Thank you. Your Honor, Kame Boom stands before you for sentencing. In cases like this one, where the charges alone provoke strong public sentiment, which undeniably evoke a visceral reaction, fueling immediate calls for strict punishment. It is this visceral reaction, Your Honor, that can often lead towards the desire to impose the harshest penalties possible. But it is in these moments, Your Honor, that require us to look beyond immediate reactions and reflect on the broader principles of justice. And it is in these challenging moments that we are called to balance the scales of justice by not only considering the nature of the crime, but also the background of the accused, as opposed to ruling with an iron fist. While the gravity of this case commands attention and it demands accountability, it is crucial to remember that the justice system seeks not only punishment, but also to guide towards rehabilitation and reconciliation, and restoration. The narrative painted by the original charges does not fully encapsulate the depth of Kame's genuine remorse, her commitment to change, and that she never intended to hurt those who were deeply affected, and the complexities surrounding this case. Make no doubt about it, Your Honor, Kame takes full responsibility for her actions, and she acknowledges her mistakes. And for those who, for whatever reason, claim that she is not taking responsibility for her actions, having represented Kame for almost the past year, I stand before you and represent that those claims couldn't be further from the truth. The very act of Kame standing before this court and entering a guilty plea in the eyes of the law is a clear demonstration of her acceptance of her responsibility for her actions. Unfortunately, the acknowledgement of accountability is often lost by the time we get to sentencing. The truth is, Kame did what many others who may have come through this court have done and will continue to do in the future. The prosecutor offered Kame a plea to a lesser charge, their choice. Kame accepted that offer. a decision aligned with common judicial practice that should not warrant additional punishment at sentencing. In fact, by accepting the prosecutor's offer, both parties ultimately benefit by not forcing the victim in this case to have to participate and testify in what would likely prove to be a very long, drawn out, emotionally difficult jury trial. The court has previously indicated when sentencing Kame, the court will not stay within the Michigan legislature recommended guidelines. Even though the guidelines are calculated by probation and the prosecutor, and this court has approved the 0 to 17 months guidelines. Notably, they do not require a mandatory prison sentence. And her guidelines fall within what we call, as lawyers, the intermediate sanction cell. A cell which more often than not results in probation, jail time, house arrest. And knowing all of that, Your Honor, the plea was still offered by the prosecution, having discussed this with the prosecution. Additionally, Your Honor, presumably, and I could represent from what I know from speaking to the prosecutor, he has discussed this plea offer prior to offering it with both the victim and the victim's family. I know, Your Honor, as a former prosecutor myself, I know I would rarely, if ever, make an offer that the victim or the victim's family wasn't fully informed of and on board with. Because we are dealing with an intermediate sanction cell in Kame's case, this court has several options short of jail or prison when it comes to appropriately sentencing Kame. Per MCL 769.31, the court could sentence Kame to probation with any probation conditions required as authorized by the law, residential probation, probation with special alternative incarceration, inpatient or outpatient drug treatment, mental health counseling, participation in community corrections programs, community service, payment of a fine, electronic monitoring, and or house arrest. Many of these options, Your Honor, Kame has already availed herself of, signing up for, attending, completing, and signing up for, again, multiple classes, multiple self-help groups, therapy, and the list goes on and on. A list of all the programs sought out and participated by Kame was provided to the court and the prosecution via the sentencing. A list that clearly demonstrates Kame's true commitment to do the necessary hard work she must do to prevent any future transgressions by making these decisions on her own, not court order. And it highlights the fact that she is dedicated to correcting her behavior. Trust me when I say, Your Honor, Kame has not gone one day without feeling the impact of her actions for almost a year now. Acknowledging that Kame has made mistakes and must face the consequences, the question becomes, what is the appropriate extent of those consequences? While Kame does not attribute her mistakes to anyone but herself, it's important to recognize the challenging interactions that she has faced over the past year when considering what her sentence should be. There's been several instances of unsolicited contact. Most recently, on March 15th of 2025, the victim repeatedly requested Kame's involvement in a baseball fundraiser through emails sent via a third-party application. On March 8th, 2025, during the night, an individual resembling the victim appeared at Kame's residence and engaged in an inappropriate behavior, all caught on video. After being told by the police and Kame to no longer have contact with her The victim continued to drop off gifts at her home and and leave letters in her mailbox. Additionally, over the past school year, the victim approached Kimmy's son multiple times, encouraging him to attend sports events and bring his mother. And for some time now, Your Honor, Kimmie has been surveilled or followed over 15 times by the very officer who led this investigation, with video evidence documenting it. The saddest part about all of this, in this particular instance, is that Kimmie couldn't even speak out about any of this. She couldn't risk the potential that somehow she might ultimately be the one to have to pay for it. Was she supposed to go to the police or have the attorney go to the police station when the police was the same police officer heading what seems to be one of his most hated cases? I say that, Your Honor. Perhaps there is some type of personal issue in this particular case. Once the officer found out that his past was being looked into. Frankly, wherever she went and whatever she did, she faced harsh criticism, name-calling, and gaslighting from the very community she once gave so much to. Kimmie's commitment to this community is reflected in the list that I had also given to the court and the prosecutor of charities and contributions to this community. Kimmie actively and voluntarily took part because that's who Kimmie really is. Unfortunately, for this past year, Kimmie lived as a prisoner in her own world, a citizen without protection, with the perception that she is presumed guilty long before her day in court. Your Honor, I share this not to elicit sympathy or empathy for Kimmie, but to provide a perspective on this case that may not be readily apparent. In light of these experiences, Your Honor, I urge the court to consider the fact that Kimmie has effectively endured a year of house arrest because of such circumstances. For someone who was prepared to receive a sentence within guidelines of 0 to 17 at the last sentencing date, where the prospect of a lengthy prison term was never anticipated or discussed, neither between the defense or the prosecution. Please consider that in my career, and it's a long one, I've not represented a single client who comes to the table with such extensive records of community service, charity work, volunteerism, and character letters that support who my client really is. Kimmie's background and character are spoken for in volumes in the letters that were provided to the court, hopefully giving the court a better idea, a more well-rounded picture of who Kimmie is and who Kimmie is not. She's a mother of 2 young children with no prior criminal record, and someone who clearly allowed her emotional vulnerability to get the very best of her. I assure you, Your Honor, Kimmie is not the type of person who fits the mold of someone who made a mistake and simply doesn't care. Kimmie's innate ability to right her wrongs is who Kimmie is. She is an overachiever. She constantly will go the extra mile or 2 just to help someone in need. And she knows the difference between right and wrong. And she screams at the top of her lungs that she knows what happened was incorrect. In an effort to continue to make appropriate choices, Your Honor, Kamei subjected herself to a psychosexual assessment with a psychotherapist who specialized exclusively in the assessment and treatment of sexual abuse and deviancy. As an officer of the court, I will tell you that the findings from the psychotherapist included the following. Kamei is at a low risk for engaging in sexual, abusive, and inappropriate acts in the future. Kamei's responses were not indicative of pedophiliac interests, fantasies, or sexual misconduct. Kamei does not exhibit predatory behavior, therefore making the likelihood of any type of recidivism unlikely. A legal argument that I anticipate the defense, the prosecution may make, for lack of better words, that Kamei is lucky to have this plea offer because they were prepared to add additional charges as discussed earlier. Your Honor, I suggest, as I did earlier, there simply is not legal merit to that argument. As the court's aware, we went through this, the age of consent is 16 years old. Once she is no longer a teacher, the voluntary sexual relationship is not sanctioned by the law. The only way the prosecutor could try to add charges under this theory is under the elements of force and coercion. Frankly, Your Honor, the elements of force and coercion go against every single statement that the victim in this case made. In fact, the victim was quite clear that he had hopes of potentially being with Kamei in the future. Given those facts, Your Honor, the defense implores this court to, under the guise, to not sentence her under the guise of how lucky she is, she got this plea, but under the guise of all these mitigating factors. While the popular assumption, Your Honor, to make about this case is that Kamei should have known better. And you know what, Your Honor? I bet if I asked her today what she thought, she would agree. She should have known better. But nobody is perfect. Circumstances actually do play a role in most people's decision-making. Acknowledging that Kamei was initially in a position of trust and should have acted differently, Kamei allowed her emotions to get the best of her at a time when things were not going so well at home in her marriage, and she allowed her emotional vulnerability to overcome her usual logic and sensibility. Your Honor, women are known for being emotional beings. Does it make her actions excusable? Of course not. But Kamei led with her heart, and that's what ultimately got her in trouble. While there is no fair explanation, nor an explanation I would expect the court to want to hear, but that little piece of the puzzle gives the court a glimpse into what was ultimately Kamei's clear downfall. And although there may be pressure to impose a sentence that serves as a cautionary tale, I suggest to you, Your Honor, this is not the appropriate case to make a symbol for all teacher-student relationships and their punishments for the future. Rather, I implore this court to consider remaining consistent in sentencing, to consider that the power to punish shouldn't be overshadowed by the opportunity to rehabilitate, and offer a path forward, particularly when Kamei has shown her genuine remorse and taken proactive steps towards potential change. The irreplaceable role Kamei plays in her family's life, particularly with her 2 young children who depend on her daily. During the summers, she happens to be the only adult who could do majority of the work. with the children, removing her from their lives would not only overshadow the rehabilitative process that she has made, or progress, excuse me, and continues to make, but would also inflict profound harm on her children. Again, Your Honor, this is not regarding feeling bad for her and the old, she should have thought of this then. It's to merely give this court perspective when it comes to the reality of what a prison sentence will entail. In closing, Your Honor, as we conclude our elocution, I urge you to consider the profound implications of this moment. My client has unquestionably made a very bad decision, one that has already exacted a significant toll on her life. I ask that you evaluate her case free from influence of external pressure and or bias. Justice should be grounded in fairness and the recognition of the potential for rehabilitation. Therefore, we humbly request that this court ensures a sentence that reflects not just the actions of the past, of which we know it will reflect, but Kamei's ability to be rehabilitated in the future. As I was planning on requesting in the first time we were here for sentencing, I am again requesting, if this court is so inclined to not give my client probation, which is what this court has already indicated, that this court will go above the guidelines. That means jail, prison. I would ask, again, that this court consider house arrest as an alternative. Thank you, Your Honor.
You're welcome. Does your client wish to address?
She does not, Your Honor, and I hope, please don't
That's
take
not
that
how it goes, sir.
personally. We've had several discussions. I've told her I'll speak on her behalf. Thank you.
No problem. Mr. Rakowski, anything on behalf of the people? And this is a victim's rights case.
It is a victim's rights case, Your Honor. The victim's parents are here. We do not wish to address the court. I have discussed things though with both of them, and as it relates to the victim's father, he wishes the court to consider prison time. So I want to put that out there. To begin with, I want to say that the Ugly Police Department did a very thorough job investigating this case. They investigated it, did search warrants to gain information, which would include the Google searches the court has access to. I wish to address a couple arguments made by Ms. Becker. One of those is she talked about the plea offer and that I'm not arguing that anybody should be grateful or not. We make plea offers based on what we're looking at. So I think one of the things that citizens that want to have something done differently on these kind of cases would be reach out to your legislature, because Ms. Becker's correct. The law says after a person's done as a teacher, they could maintain a relationship, unlike the medical field where there's like a 2-year look back, which it should be the same in this one. We were willing to explore and charge the matter for that happened after she was a teacher, but we don't know how that'll turn out, given that we'd have to work our way through the court system. We've done that before, not always been favorable for us, but we're willing to make that attempt under the circumstances. But we look at various things. We talk to the victim's family about the plea offer. Sometimes we'll consult with the police, but I'm never going to sit there and say, well, this is what the victim wanted, because that's victimizing the people again. And we're not going to do that. I listen to their comments. I listen to the information that I have in front of me from CAC. And there's a number of things that go in there, whether or not the victim would testify and how well they will do. Those are all things that we consider. And then we look at some things. So in this matter here, Ms. Booms is convicted of a felony, so she's not going to be a teacher anymore. She's going to have to register as a sex offender. And those are important things too, that are going to be included in the sentence for today. So we look at those things and then we assess the matter in making our plea offer. And based on the assessment of what we had, I extended this plea offer. So, we believe that the pre-sentence investigation in this matter is accurate. We believe that it includes all the information from the investigation. I think the court has what it needs to in front of itself. But at the end of the day, we get back to Ms. Booms was in a position of authority. There were some descriptions given by Ms. Becker as to potentially this could have been the victim on this video. There were things that were sent, but I think she also then answered what I would say. That is, this is the grooming process. And this young man believed that there was a future with him. And so that's why, I'm not saying he did some of these other things, but if there's any argument as it relates to contact, it's based on the grooming part of it. And I'd point out also for the court, and it's in the pre-sentence investigation, so the matter is sent to us for determination of potential charges by the Elderly Police Department. We had it for a few weeks. And in the meantime, as it's listed off in the report, Ms. Booms is found over here by the FedEx library in a car with the victim. So I think, given all this information, we ask the court to fashion a fair and just sentence with what you have in front of you.
Ryan, may I briefly respond? Because this is the first time I'm hearing, actually, the prosecutor told me right before we started that dad wanted prison time. I just addressed that from.
Sure, if you wish.
Thank you, Your Honor. Your Honor, obviously, victims families, they're entitled to have their voice. They should have their voice heard. I just frankly found it fascinating that today we found out that dad wants prison time, because what I was told is that when this initial incident came out, dad was the first person called. Dad basically high-fived the kid, the victim, and didn't even tell the wife about it. Now, I get it. Things change over time, Your Honor. But coincidentally, at a point where you've indicated that you're going to go above the guidelines, today, the dad now, perhaps it was before, but I was never told that he wanted to. He wants to see prison. Lastly, Your Honor, regarding the dates on this, I think it's really important that we don't forget, Your Honor, for the victim himself, we don't know the dates. I think isn't necessarily gonna fly. I'm not suggesting it didn't happen, but I think with the dates are extremely important, because what that means is she very well was not in a position of authority when any of these alleged incidents occurred. And I hope that can be considered in terms of her sentence. Thank you, Your Honor.
Mr. Rakowski, did you wish to comment anything regarding any of that? You don't have to. I just want to give you the opportunity.
Well, as it relates to the CSC fourth count, there had to be the teacher-student relationship device. That wouldn't have been the case. And I don't think anybody disputes the date, because it was one we talked about with the court at the sidebar at the time of the plea, that the gross indecency, that's related to, the date of July.
All right. Well, first, just to comment, I guess responding backwards to the comments, the last one about high-fiving the victim in this case, and no prison time originally. I guess that kind of goes back to the court's position on this, that you only know what you know. And at the time the court entered the plea in this matter, it was the obscene conduct charge and the tapping of the buttocks, I recall from the CSC 4. That's all the court knows. The court doesn't have the opportunity to have a police report within the file. We don't want a police report in the file because we hear the evidence presented here in the courtroom. So I guess one way of explaining this alleged incident of father of the victim high-fiving the victim could be either one, stupidity, or two, a lack of knowledge regarding what happened. Because certainly when the court took the plea at the time, the court did not know of everything that was going on. Now, the pre-sentence report clearly shows that. Regarding the issue of external pressure, this court is not pressured by anyone or anything relative to a sentence. Believe me, I've read the comments about how bad of a judge I am because I don't give them life, or I don't do this, or I don't do that. I hear it all the time. I've heard comments from individuals, I wouldn't say comments, but individuals coming up to me and saying, well, you need to either take it easy on this individual or you need to throw the book at them. Again, I take those comments respectfully, one ear and out the other, because these individuals don't understand what is going on factually. And sometimes people make comments that if they knew the factual information, specifically what's contained within a pre-sentence report and what may be contained in sentencing memorandums, etc., that's all you have. And that's why you can't judge, or you can't jump to judgment on an individual. And that's just the way it is. Now, what we have, though, if you just read the sentencing memorandum and all the letters, we have an individual before us that shouldn't be before us. In other words, an individual that knows better, not only knows better, but is a fixture in the community, an educator, supporter of children, supporter of the community, charitable functions, everything that she does, and no prior criminal record to speak of. I mean, if you just read that alone, that should take care of the matter. But there's an old saying from an individual who's since passed called Paul Harvey. And now the rest of the story. And the rest of the story is this relationship between the victim and the defendant. While the victim was a student at a local school. Now, yes, there was a point in time where the defendant left her profession, and in some respects, no harm, no foul. I know you're not making it sound like that, but that's what the law is. And in some respects, I agree with that. But here's the problem. This relationship started when you weren't educated. And it should never have started. And when you read, and again, the court can only sentence an individual for what they've pled to, not what they may or may not actually have done in the home or in a car or whatever the case. It's based upon the factual plea that's entered based on the charges. And, one would ask this question, and before I even pose that, going back to this comment about, people shooting off comments and making statements, the same goes regarding plea agreements. I was an assistant prosecutor. I was a defense attorney as well. I know both sides of this and how difficult it is either prosecuting or defending these types of cases. And sometimes as a prosecuting official, you have to make or you engage in plea discussions and plea agreements because there may be something factual in the case that may be incorrect or something that could potentially lead a jury down another path. It could be the alleged feelings of the victim. There's a lot of things that go on that even this court doesn't know of, and I still don't know. I know what's contained right here in the pre-sentence report and in this file, and that's it. So I'm not going to stand here and question what the plea agreement was. If the parties agree and they have a plea agreement in mind regarding what the plea is, the court's going to honor that. Now, sometimes the court in the past has, in this situation, said that it would follow the guidelines. And I've already stated I cannot follow the guidelines based upon what I've read because that's the rest of the story. And the rest of the story, frankly, is appalling. And then to add insult to injury, and this has no bearing upon the sentence of the defendant in any way, shape, or form. However, there was, according to the pre-sentence report, communication between the victim and the defendant's husband. There was a text message, and this has no bearing on the defendant, but it just goes to show you what's going on here. The message stated, "She does not deserve to go down for this after everything she did for us. We all know it's you. If you care about her and her family, you will do everything you can. Talk to her. She cares about you." Nothing happened while she was at the school with us. I mean, you can't write a more tantalizing quote script regarding this. And it begs the question as well. The scales of justice, Lady Justice is right before me, and she's blind. She's blindfolded. The reason she's blindfolded is we don't look at the individual and say, for instance, well, you're this, you're going here, or you're that, because of how you look or how. And it comes down to race, it comes down to gender. That makes no difference here. The question, though, would be, how would someone look upon this if it were a male teacher? And to this court's position, it doesn't matter. Male, female doesn't matter. Race doesn't matter. The position matters, though. That's the problem this court has. And there was a reason for this plea agreement reached between the people and the defendant, and the court is not going to stand in the way of the plea agreement, but the court does not have to accept the recommendation in this case. I understand what the recommendation is because the guideline range is 0 to 17 months, and the court finds that that is properly scored. The problem, though, as far as the court's concerned, relative to following the guidelines in this case, is when you look at the history of these parties, primarily as an educator of this particular child, there is an intense form of grooming here. I don't know how all of a sudden a relationship begins between an individual in the teaching profession and a student. I don't know how that works, but it did in this case. And there's only one reason for it. When you read all the information contained here, if there's a problem at home, whatever the case may be, that's one thing. But you have to pursue the relationship. That's the grooming part that this court finds. And the guidelines don't articulate that. So that's why, relative to the sentence in this case, the court will not follow the guidelines based upon the grooming. Now, there was also a feeling by the court initially of lack of remorse. When the plea was entered, it just kind of seemed like a nonchalant type of plea, and there was no issue. And the court looks at body language. And it was the court's thought originally after the plea was entered, it maybe appear that the defendant doesn't get this. But after reading the not only the pre-sentence report, but more importantly, the sentencing memorandum, the court finds that there appears to be remorse on behalf of the defendant. So I'm not using what I thought she felt, because that's more subjective anyway. But I find that there is remorse here. Sadly, though, we have to address what's at hand here, and that's the behavior of the defendant. As a result, I'm going to begin with count 2. Will be the sentence. This court is to count 2. The court will be in the guidelines regarding this one. The defendant shall be committed to the Michigan Corrections Commission and placed in the commission's custody for a period of not less than 16 months to a maximum of 2 years. The 16 months, the court considers the grooming that was done in this matter, which is not covered by the guidelines, intense grooming, the court finds. In addition to that, the court has to consider People versus Tanner under 387 Mich 683. It's a 1972 case. It's called the 2/3 rule. And individuals sometimes wonder, well, why don't you just give the 2 years max? Well, there's a reason for that. The Supreme Court has told us that we must be proportionate to the seriousness of the circumstances surrounding the offense and the offender. And the 2/3 rule applies. And I'm also citing People versus Milburn at 435 Mich. 630 in 1990 case. The Tanner rule is the 2/3 rule. 2/3 of the maximum is 16 months, hence the sentence of 16 months to 2 years. In addition to that, the defendant shall pay following. That is court cost of $500, a fine of $500, payable at the rate of $10 a month, DNA testing of $60, and I believe that covers that one. There's also no days credit relative to the sentence. As to count one, here the charge of indecency between male and female committing or procuring. Court will not impose any additional court cost, fine of $500, payable at the rate of $10 a month, DNA testing fee of $60. Health department is to be paid $141 for the HIV testing. And it's further the sentence of the court pursuant to People versus Tanner. Defendant shall serve a minimum of 40 months in prison to a maximum of 5 years with no days credit. It's my duty to inform the defendant she has right to seek leave to appeal. If she's financially unable to provide counsel of her own choice, court will assign counsel for her public expense. She's to initial the receipt questionnaire form requesting the assignment of counsel, both of which must be executed under oath, filing as court within 42 days. She's also to register as a sex offender as well.
First question. Both files, correct?
On both files, yes.
And fines assessed both counts? Or
Yes, I did assess fines on both.
on both counts? Okay.
Yes.
Thank you. You're welcome.
Your Honor.
State, I need state minimums on both as well. I apologize. I thought I did, but if I didn't, crime victims' rights fees will apply as well.
And just one.
One DNA charge. Yes. Yes, all sentences shall be served concurrently with each other.
And Your Honor, the sentences that you just indicated, I apologize. They're one concurrent,
Yes, they run concurrently with each other.
and if you said that, I apologize.
No, I just said it while you were speaking.
Okay, great. Additionally, my objections with the guidelines were for both counts, just for the record.
So no,
Thank you, Your
so
Honor.
no. That'll be all.
May I have a moment? Does she have to turn herself in this moment? How does that work then?
I turn it over to Lieutenant, whatever arrangement you want to make with Lieutenant is appropriate. But otherwise, you're managing.
Sure. Thank you.
There was plenty of talk about growth, confusion, and emotional fallout, but very little about the crime she committed. The judge called it what it was, grooming, and rightfully sentenced her to 16 months to 2 years in prison. Whatever loneliness, marriage problems, or charity events she did on the side doesn't erase that reality or make it sound less predatory. Why does female guilt always come with excuses and disclaimers? Would a male defendant have made it through sentencing without the word predator being used, or even given this much space to reshape the narrative? Let me know your thoughts in the comments, and don't forget to like, subscribe, and hit that notification bell for more gripping courtroom moments. Thank you for watching. See you in the next one.